All right. Okay, I think we're going to go ahead and get started. Leslie, the president, is at a track meet, and so I am filling in. Just a couple notes about upcoming training is next month is Foster Care Appreciation Month. So the coalition will be supporting our meal. We're hoping to do Olive Garden, and there'll be some little gifts and stuff. So make sure you sign up for that. Then in June, we'll also have a regular meeting. In July, we're taking the month off. So if you're planning ahead for training, we will take the month of July off, no training. August will be our picnic. So that will not be regular training either. So just FYI on some of those summer months. Yes, Lori? I do. I will. It's the second Tuesday in August. Yep. I think it's the 13th. So we got that reserved, and hopefully we can do Super Slide again. So that's the plan. Yeah, we can get some of those dates out for you too. So, all right. So tonight, we're very appreciative for Shayla Schultz being here because we kind of had some issues with, what would be the term, Leslie? We thought we had everything together and then it wasn't together. And we were like, we don't have a speaker for Tuesday. And it was like Thursday. We're very busy foster parents. Anyway, she stepped up and was willing to come very short notice, and we're so grateful. So Shayla is with Burleigh County, and she is a child welfare trainer. Okay. And then she's got Peggy Netzer from the county here with her too as support and help too. So the topic tonight is just kind of the court system and how things look from that viewpoint. And I know a lot of us foster parents either have no experience with that or a little bit, and just kind of a way to understand a little bit how the court process works. So I can hear myself. All right. All right. So I will go ahead and hand it over to Shayla and Peggy.
Thanks for letting us come. I guess it's not a big deal to just jump in on the fly because that's what we do. So they wanted me to talk about the court process, the court flow, kind of how foster parents can support kids throughout the process, and kind of help with coming up with a plan too. So I guess I'm not really sure where to start. Is anybody? Yeah. That'll be good. Oh, I see a hand. You're first. I was going to do that. The question was on concurrent permanency planning and how a concurrent plan comes into play. The court system doesn't have anything to do with a concurrent plan. That really is on the zone and the child and family team to make that decision that they're going to add that plan B. Anything else?
So we do have guidance. The 12-month thing is a real thing. When we hit that 12-month point, we are required, so to say, to have a concurrent plan if our plan is not making progress. So we don't have to have a second plan, right? But if the plan that we've been working for 12 months is not going anywhere, we need to be thinking about other permanency options at that point.
Anyone else? Okay, good.
So, sorry. So just start like first, sometimes like we get shelter care kids and you'll say, oh, the court only has them for 5 days, 7 days, 8 days, whatever. So why is that different than like, okay, now we're going to take on a kid. full-time in care and we have a court order for 30 days, like what are the rules? What are the regulations? How does this stuff differ?
Well, I'm not going to say it's not confusing because it is. We actually have shelter care used in two different ways. So there's a shelter care that we can utilize for kids for 7 to 14 days, and that is not completely taking custody of the kids, but the parents are agreeing that they can go stay in a foster home and it's considered shelter care. So that is when we don't take custody of kids. Um, the workers and the parents have to agree to it. So they just have to be licensed. It comes out of a different payment, I guess. But yeah, so let's just say mom is being arrested and there's nowhere for the kids to go. And we know that she's probably going to be in there for a couple days. And when she gets out, that the kids can go back home. So instead of taking full custody of them, we could utilize the shelter care program. The other shelter care that we're more familiar with, most likely, is when we get custody of kids for 30 or 60 days. So if ICWA applies, they will only give you shelter care for the 30 days. If ICWA does not apply, then you're going to get shelter care for 60 days. And that is after kids initially come into care with that emergency removal. We go to court that next day, and then they'll grant the shelter care order for 30 to 60 days. After that, when we're a couple weeks into that shelter care, we're going to file an affidavit to ask for a 12-month custody order. Kind of how that goes. We got 15 days from the date of removal to file that affidavit for that full 12-month custody order. Any more questions on that? Okay, so after, let's say we go to court, 12 months is granted. We have to go back to court in a year, which is called, we're asking for a permanency order to extend our custody for another 12 months. Our guideline or policy now says to get the workers have to get their affidavits to our state's attorney 3 months in advance, to give them enough time to review it and get into court soon enough so that court or the order doesn't expire. And then anything on that? Okay. Question. Oh, yeah. Our affidavits are, they really just keep adding up. When I write an affidavit, I take my old one and I just keep adding to it. And I'm really writing, our affidavit focuses around why is the child still in need of protection? What has not been done or been done on the parents' end to make it safe for the child to go back home? And we go into like everything, all of our active efforts, everything that the zone, foster parents, community partners, everything that we've done to help support the parent and why they have or have not worked, basically. What did you say before that? Okay. So foster parents do have the right to get notice of all of our court hearings. So you should be getting written notice of court hearings. If you're not, let me know. If it's with Burleigh County, let us know. We'll make sure you're getting those notices. You should have enough time to be able to attend. if you get to court and the parents are like, nope, I don't want them here, then the ref will ask you to leave. But otherwise, I've never had a time where they've never asked them. But you do have the right to be notified and be present as long as all parties agree once you're there.
It might not be a formal service like notification to you. It could just be an email from the caseworker that's or text, whatever, that says, hey, we have a permanency hearing in, on May 1st at 10 p.m. So that's your notice, right? It's not going to come from the court system because you as foster parents are not a party to the case. So you do not receive service for the hearings, but the case managers should be letting you know when there's a hearing, and it's your choice if you want to come to the hearing or not. We are back to the point where our hearings are all in person. So it's not as easy for foster parents to attend as it was when everything was on Zoom, right? And you could just log in for 10 minutes and be done.
Real convenient for all of us. Okay, what's your question? Oh, microphone.
If you have a placement like out of like your local county, are you able to like Zoom into those court hearings, or you have to be present for those? Or is it?
It really depends on that court.
Okay.
If it were our court, I would say no. The only people that are allowed to attend by Zoom is the ICWA worker and a parent if they're incarcerated. Yeah, all the courts are different too.
What is the process for ending that emergency order? If court, does it have to go before the court, or can the workers on their own and the lawyers work with something? The case we have, court has been canceled now 3 times. It was supposed to be in December, and the next hearing is not until the end of June. And the mom's done everything she's supposed to plus. Yeah, like, so does it have to go to court, or?
It really does depend. It really does depend on your state's attorney, and it depends on your court. If we're, I'd say 90% of the time we're going into court to amend an order, whether it's to end that custody order and change it to a supervision order. Okay. Do you want to elaborate on the emergency order that you're talking about? Is there custody granted, or are you still in?
So I'm assuming we're under that year order at this point. They've been with us since October. So there was court.
60-day court was canceled in December, and now it's been canceled 2 more times.
Yeah, so you're still in shelter care. What's happening is that shelter care order is getting continued until that next date, and they could go into court and then say we don't need custody anymore.
Okay. So does that have to wait till June then, or could that be done through filings before then?
There are some cases where we can write an affidavit to the court and request to terminate our custody. It's generally used in cases where kids are placed with a relative who lives on the reservation and we have a power of attorney in place. So they don't need anything from us, right? When kids are in a foster home, we don't generally do that because then there's nobody to take care of the kid, really. If we don't have custody, foster parents don't get paid. They're not going to keep kids just to keep kids. If you're still in shelter care, they absolutely do have to go to court. The court sets a calendar. We have zero control over that, unfortunately, because let me tell you, there's a lot of them we'd like to have sooner. But if you're saying that the parent has done everything to achieve their case plan goals, then that would be a conversation with the case manager. And if you're not getting a good response, go to the supervisor, because there should at the very least be some sort of like unsupervised visits and trial home visit and all of those things in place between now and when you have that shelter care hearing. So when they get to that, they can say, here's all the stuff that we've already done. This parent has, met their case plan goals. We have achieved reunification. We need you to write this order that says at the time the child was in need of protection, but they aren't anymore. Okay. And the reason we need that order is mostly for you guys, honestly, because if we don't get an order that says that child was in need of protection, you don't get paid. So all the money that you've received since October, you would need to pay back to the state. So it's really important that we have those hearings. And yeah, we don't have control over the court calendar at all.
Just a thought that came to my head is the case manager or the team could decide to do a trial home visit with the kids and put them back with parents while they're still in foster care, which would the trial home visit, yeah, would be where the zone still has custody of the kids, but they are placed with their parents or in their home. Usually we've worked our way up to it, but
Yeah, the meetings
Go
are
by-
super confusing.
I'll
without it.
go by the rules. Okay. When we get initial placement, we receive very little information at all about the kids, which is fine because we don't need to know probably a lot of it. But as these court cases go on or the hearings, like, are we privy? So say we can be at the hearings, are we privy then to some of this information about the parents, about why they were pulled? Is there still anything, I guess, that the foster parents are kept out of just for privacy reasons for the bio parents, or is it kind of once you start attending these or getting information, you do get the information?
if you attend a court hearing and all the parties agree that you can be in that court hearing, you're going to hear all the information. And we are working on trying to figure out a better way to get more information to foster parents when you initially get a kiddo under emergency.
I was just going to say, with those initial placements, like a lot of times we can't tell you anything because we don't know, especially if the call you're getting is from case management team as opposed to CPS worker. CPS worker is going to have a lot more information than we have at those early stages. If it's a kid that we've had custody of for a year, we know everything and we will tell you everything you need to know to be able to parent them. But those emergency kids, we just don't know. We revamped our, if you've taken a placement recently, you'll see the new form that comes to you. It basically says, this is what we know. We have the kid's name, their date of birth, the case manager, the case management supervisor that you would contact if you need anything. It has phone numbers and stuff, but we don't have a Medicaid number right away. We don't have a social security number right away. We don't always know the birth date right away. Sometimes we don't even know the kid's name. So if you're taking emergency placements, thank you. We know it's hard and it's extra hard when we don't have more of that information, but our goal really is for the case managers when they complete that initial visit with you, that, 7 days thing, that they will come to you with a second form that has more of that information. And within that first week, we will find out a lot. We won't probably still have a Medicaid number, but the rest of it, we probably can answer a little bit better.
Just a follow-up question on, you mentioned like if the parties agree that the foster parent can be present, but I think you said that doesn't happen very often, or it usually does happen. Like, are foster parents usually okay going in there or not usually?
Yeah, I say typically everybody agrees that foster parents can be in there. If for some reason a parent doesn't, the judge will typically ask you to leave then.
It's the same with other. So you're considered an interested party, not a party to the case, just like a grandma or neighbor that might have the kid, right? So as an interested party, you are allowed to be in the courtroom. If you are not the foster parent for a kid, there's no way you're getting in there, right? Then you would not be an interested party. You're just a nosy person, right? So, but if you're an interested party, just like grandparents sometimes will come, and then you just have to basically get permission from the parties, which would be the parents, the state, the court. And once they say it's okay, you can stay.
I hear sometimes about like foster parents having to testify. Like, how often does that happen? At like what stage would a foster parent be asked to give information?
No, I've never had that happen. I think it definitely depends on your state's attorney. For termination of parental rights would be probably the most appropriate trial that you would testify at. It really doesn't depend on your state's attorney and if they feel that testimony would be needed. So I mean, your state, that would be up to your state's attorney if they would want you to test. Yeah. They want to try to stay away from having foster parents testify just because that just makes it kind of messy sometimes, or if you have a relationship with that parent. So
if you are called to testify, our state's attorney would absolutely make sure they're focusing on the positive. Like, hey, you know this parent, you are willing to adopt this child, you have this relationship, you're willing to continue this relationship, these are the supports that you're providing for this family, not anything about what that parent has done wrong, what your opinion is of that parent, why you think you're a better parent than they are, nothing like that. Because we really, really, really want to preserve those relationships, because we all know it's better for kids if they can see their biological family and their adoptive family as a whole. So.
Shannon.
Okay, I have a question about review hearings because it's one of our kids, I feel like we're in court all the time for review hearings and then most of the others not. Is that like a common thing for the review hearings, or is this just like, I mean, it's so weird because one kid, I swear we've been in court like 10 times. And most.
You don't know?
I get them, I mean, we've had them so many times. So yeah.
It really does depend on the case. Sometimes the judge is so a review hearing is basically all the parties just getting together, coming in front of the judge and saying, here's where we're at. This is what's going on in the case right now. Here's where we're at. What's changed? What hasn't changed? Do we need to change our custody order? Is kind of where we're at. Some judges are like, hey, I think that we could come back in 6 months and see where things are. It really does depend on your court and your state's attorney with review hearings. We don't have too many review hearings, but occasionally you'll get those cases that are a little bit more, yeah.
I was going to say that it was contested. This one's a little more contested than some of the other ones we faced. So yeah.
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 There's a lot of moving pieces, a lot of people, that kind of thing. Sometimes it's cases that there's a parent who lives out of state and we have to do an ICPC, and the court will say, here's a 12-month order, but we want to know where you're at on that in 6 months, right? Or if the parents have not been involved in the way that they should, but there is a change coming. So let's say they're incarcerated right now, but they get out next month. then we may have court now and they'll say, yes, you need a 12-month order, but we want to come back for a review hearing in 3 months and see where we're at with things. Because sometimes the court does come at us and say, you know what, these people have had enough time. We need you to come up with a better permanency plan. That's usually what happens in those. They're mostly the messy ones. So you must have a hard one.
A lot of times too, when parents are contesting, we'll end up coming to an agreement of 6 months, which will bring you back to court more frequently. No, the state's attorney, it's usually the defense or even the court will say they want to. Mm-hmm. Yeah, the child's attorney can definitely ask for that.
Yeah, wait. I knew that was coming. I felt that was coming.
So the question is, how does a child get an attorney? Once, yeah. Yeah. We used to have to fill out an application for them. The case managers do fill out an application for a court-appointed attorney, and they get assigned one just like a parent would. Mm-hmm. Yep. They do. They approve it before the hearing. The child can request one. We can request one. The state's attorney can request one. Yeah. This is, yep, if you're 14 and up.
Guardian ad litem can also request for the child.
That was my question. Here's your question, Leslie. What are some ways foster parents can assist the child welfare team when it comes to court, and how foster parents can support the child through court?
So assisting the child through court is, I mean, kind of what you're doing every day. Just being able to talk with them about it, processing through, maybe prepping them a little bit, like, hey, we have court today, or, you know, and just kind of being on their level. I mean, what do they know about court? What do they need to know about court? Do they need to be at court? And if they have to testify in court, our state's attorney will set something up to meet with them or prep with them before court, probably the week or two before.
So they know what she'll ask.
Yeah, yep, they'll definitely know. If they have to testify, they'll know what she's going to ask them. What was the other part? The team?
Yeah, can assist the child welfare team through the court process.
I think, you know, a lot of those child and family team meetings, we talk about permanency planning, and we gather a lot of our information in those meetings or at home visits with the foster parents and the kids. And when you're talking about that family connection or visits or how involved they are or aren't involved.
I think the biggest thing as foster parents that you can do to support our team in any way is with good, open, consistent communication, honestly. Because if you're seeing things at home and we don't know about it, we can't do anything. And we want to be able to help, right? And so same kind of thing, like you'll see positives at home that we don't see. You'll see behaviors at home that we don't see. You'll sometimes be supervising calls with parents and we don't see that. So like anything that happens that you're like, you know what, documenting it, like if you're doing calls for kids 5 days a week and we don't know that, then we may be, trying to set up other things and it's like really a duplication when you got it under control already, right? So I think as far as court, same thing. Make sure that your case manager has all the information that they need to be able to do their job really well.
All right, another part of the question was, what are some of the kinds of services involved and available for children, like depending on the type of court process or trial? Like what do foster parents need to be aware of? Say if it's a criminal trial, how can we support the child? I guess like the services, I think like the attorneys, I mean, we didn't know about that or most of us didn't, but what other services are there for our kiddos?
Yeah, so mainly it's going to consist of their therapist if they're in therapy, and just kind of being on the same page as the therapist, letting them know what's coming, how they're feeling about it. If they do have to testify, whether it's for a criminal or for their own juvenile case, the attorney will prepare with them. Don't be surprised if the attorney doesn't reach out to you till the week or two before to set that up, because that's super common. There's really, I mean, that's really what it is. The guardian ad litem will meet with them and is there to kind of talk through that process with them and represent their best, what's in their best interest at court.
So permanency hearings are totally different than a TPR hearing. So when it's a termination hearing and kids know what that means, that's where you really want to make sure you're connecting them with therapy, because even if they don't want to go back home, even if they want to be adopted, it's still really, really hard. It's hard on us. It's hard on kids. It's hard on you guys. It's hard on the natural family, everything. And so even if it's a good thing, it's good for them to have someone to process that with and make sure they know that it's okay that they're feeling that grief, because they kind of think it's not, right? They feel like it's being disloyal to this family that's done so much for them and it's going to adopt them if they feel sad at all about what they're giving up. And really they're losing a lot while gaining a lot. So just be supportive of that and understand that there's going to be a lot of feelings around it and support them through that. And if it's kids that your family is not adopting and we're doing a TPR, it's even more important for you to be able to support them through that, because they don't have that final answer, right? Like they don't have the, okay, I'm losing this family in this way, but I'm gaining this family in this way. They're not yet. They haven't got that identified adoptive family yet. And so just to help them like, okay, this is why our family is not adopting, right? This is why it's not the right thing for us right now. It's not about you and that we don't like you. We absolutely love you, but we want you to have a forever family that's whatever it is, right? But those kids may need extra therapy. They may need a little more grace when it comes to behaviors than they normally do, just because those feelings are going to be big.
So I saw this on the ND Region 7 website or whatever it is, or Region 7? Is that what we're? Okay, okay. It was asking like, when can you write to a judge or something like that? I mean, I just don't think that's appropriate at all to do that. But like the state's attorney, is it like, I know like I said, in the same case we've been talking about, the very first review hearing, we thought the state's attorney dropped the ball on a lot of information. A lot of information didn't get conveyed that could have assisted in what the order could have been going forward. I was like, and I'm sort of a go-getter. Like I wanted to go contact everybody and their mother. I'm like, what are the limits of that kind of thing, I guess. So
So per policy, foster parents have the right to be notified and have the right to be heard. Every court or juvenile court has their own way of interpreting that. So the way our juvenile court is asking is that foster parents can write a letter, or basically you give your information to the case manager and the case manager brings it to the state's attorney. If you write a letter, that could potentially go into discovery. That's given to everybody. The other attorney is that's really how our juvenile court wants that to be handled. That's unfortunate that your state's attorney, that you didn't feel that that was, you know. Yeah. Sure. I mean, the state's attorney is the huge role. I mean, that's their game, you know. They are they're leading that. So we can't tell our state's attorney one way or other either. So
but you can make sure that the case manager who's testifying has all of that information, because when we're testifying, sometimes we add things in that we're not straight asked because we know it's important, right? So as a case manager, as you spend more time in the courtroom and you get really good at testifying, you know which things you need to include, even though it's not asked directly. And so it's really important for the case managers to have all that information. And yes, you have the right to send a letter to the court, but if you do, just be aware that literally everyone who's associated with that case will see what you wrote. So think about relationships that you have with all of those people. And if you make the decision to write the letter, just be prepared that it could change some of those relationships based on what you say. Yeah, smart. You filtered it.
it's happened though. I had it happen not that long ago. Monet.
So I have a case where an outside entity was hired to come evaluate the child for potential placement. Hired. They were assigned by the court. It's a guardian ad litem. Okay, assigned by the court. Yep. This person spent less than 10 minutes with this kid and was hostile the whole time. And this is a kid that will need OT and probably play therapy, and he has a lot of needs. And I want the people to know that, because she doesn't. I'm not talking against her. I'm not talking against Burleigh County. I think his case manager has done a fabulous job. But they need to know, hey, this kid does need OT. He goes twice a week right now. This kid does need attention, and he is precious. You know? I don't know, why would that be wrong? Or stupid? Right, because I mean, his case manager can have it. I don't care, you guys can have it. I just want to make sure that the people involved
we should know that too.
He does, well, the case manager knows that, but I want to make sure, like, so this is an outside, so this is from Pine Ridge, right? So it's not our court, it's not my normal people. I just want to make sure they know, hey, this kid is precious, you know? I'm not trying to get people in trouble or dig where I'm not supposed to dig. I just want to do what I can to make sure he ends up at the right place.
So I will tell you that possibly the guardian ad litems, when they meet with kids and foster families, they don't have all the information. That's why they're asking you. But after that, they come back to us. And that's when the case manager is like, okay, nope, this kid at Monet's has OT and this, right? And this other one sibling has this and this and this, and the other sibling this and this and this, right? So by the end, when they file their report with the court, they have the full picture. That what they file is, it comes to us, so we know. But those kinds of things, absolutely. You don't need to write a letter to the judge for that, though. You can tell that to us. Tell that to your case manager, because those kinds of things need to be included in our tools that we use for our team meetings, because it gives the point of them is to give a picture of that kid, right? So Shayla can pick up a tool, I can pick up a tool, and we can read it and we can say, okay, this kid who's placed with Monet, this is him, right? We can read that and we can know this is him. So if we need to come to your house for a home visit, we know what we're walking into. You know?
Oh, he's a great kid.
He is. He's
Need to
adorable.
know. He's gonna need some OT.
Absolutely.
And that's okay. He'll be fine. But
He will.
and
He's
I know
really
his
cute.
case manager knows that. But if this lady goes to the judge, she was there 10 minutes. She didn't even talk to him. You know, she didn't try to play with him. And when you're 3, you got to have people play with you in order to talk to him, you know?
Yeah.
Anyway, that's why I was like, have you ever done that on Facebook? Because I'm like, I've not done that. But in this case, I feel like there's information that needs to be known.
Yes.
And maybe his case manager will take care of that for me. But
He did,
that's
just so you know. I can assure you that your case manager took care of that.
he's a great case manager. He's fabulous.
He has a really good supervisor too.
And you know, but I've had this kid a while now. I'm a little protective of him.
You should be.
And I'm not impressed with 10 minutes of standing in my living room. Okay. I want you to play with that child and, you know,
Because,
I
okay,
want you to love him as much as I do.
so court, this is one thing that we don't talk about a lot is jurisdiction. And we have quite a few things. I know you guys had a thing about jurisdiction not too long ago, right? But like last month? Okay. So in some cases, I'll use this one as an example since Monet brought it up, but like when the tribe says we want to take jurisdiction, then that comes to our court and our court says, okay, because we don't have good cause is what it's called. We don't have good cause to not agree to that. So then they have a certain amount of time where they have to make a decision on whether they are going to accept it. So their social services, their state's attorney requests jurisdiction. Our court says, we don't have good cause to say no to you right now and fight this battle in court. Then they have to make a case and they assign a guardian ad litem, just like we would in our court. Their guardian ad litem talks to their social services. They talk to us. They talk to you guys. They talk to the kids. And then they have to make a report back to the judge. The judge then decides, are we accepting jurisdiction? So in this case, it's been going on for, at least 6 months already. And we still don't know what's happening. No. If he's going, we want him to have the best chance at a really good life, right? And so what happened is the guardian ad litem from South Dakota comes up here, meets with the kids, meets with us, meets with the foster parents, and then gives a report to the court. And the judge then says, okay, based on this report, we will accept the transfer, which means they come and get the kids and take them back, or we will not accept the transfer. And Burleigh County, it's your case, right? So it's a whole big old process. It does not happen very often. Like this is the first time I, in 4+ years, have had a tribe actually ask for jurisdiction.
Maybe one other time, but it's very rare. And I think in this case, correct me if I'm wrong, the case manager has talked with the family members too and updated them on what the kids' needs will be or are.
But yes, your communication, your input is super valuable to us.
I just want to protect them.
That's what we want. For you guys to be that protective of kids that you would even consider calling a judge.
And so like that, you know, we talk about that stuff at the child and family team meetings, and those team meeting notes and those tools that Peggy's talking about go into discovery as well. And so all the parties in the court will get all of that discovery.
Well, it's not hate mail, it's just
informative writing.
So I know. So you talked about the difference between review hearings and TPR meeting or TPR hearings. So say we're scheduled for a review hearing for this one child after the end of the second year. But in the meantime, they decide they're going to go with a concurrent plan that, first of all, they're talking guardianship, they're talking concurrent adoption. Do they decide that next review hearing that they'll go TPR the next time?
Nope.
Okay.
That's decided typically in our child and family team meetings what those concurrent plans are going to be.
Okay.
And then we can file a affidavit and petition for a TPR at any time.
So basically, it's a decision basically in child and family team meeting. Okay.
Yes.
Okay.
Any more questions? Any more questions on TPR hearings? Because I know those can get tricky.
Hello. Just kidding. Should we expect that if the kid needs to, what's the word for it?
Testify.
Thank you. Newbie over here. With the case right? Yeah. Okay. That's all. Just, we'll be notified. She's not going to be like, what?
No,
You know, and have to-
100%.
yeah.
The case manager will be talking about it with all of you. And
Okay.
I mean, the state's attorney will be talking with her. And yes, for sure.
You should know. When it's a TPR hearing, those are scheduled out like a ways. So you should know far enough in advance if there's a TPR hearing scheduled, okay? That's not something you find out about the day before, like, you know, a shelter care hearing or sometimes our initial hearings, we don't find out real far ahead either. So TPR hearings, you find out at least a month ahead, probably 2, maybe 3. So if the child needs to be there, you will be told, okay? Also, if the child needs to testify, you will have some communication from our state's attorney's office to schedule witness prep so that they know what they're going to be asked. So they have a little bit of time to think about their answers and they're not caught off guard in court because it's stressful. I mean, your first time testifying, it's nerve-wracking, man. You're in the courtroom, you've never been in a courtroom before, and then it's all new stuff and there's people in suits, and we want kids to feel as comfortable as possible. So yes, you will know ahead of time if a kid needs to be there.
Is there an age limit, like at a certain age they can testify, or is it depend on the ability of the kid or the maturity?
Yeah, it really is on the ability of the kid and the state's attorney, what they want, what they feel they need.
We've had like 6-year-olds be really good witnesses, and then we've had teenagers that are just fall apart on the stand. So it's really about that kid and how compelling of a witness they can be.
And how it's going to affect them. I've had our state's attorney want a 5-year-old to testify, and I really did fight that because I really didn't think that would be good for that kid to sit in front of the mom and say that stuff.
For your guys' side with court hearings, like what does the week look like? Do you have certain types of hearings on certain days of the week, or like give a little bit of background to that?
No, we get hearings any day, anytime. Friday at 4 o'clock or, Monday at 9 a.m. Yep. 4:30 today. Wherever the court can fit them in, they can. I know they like to utilize Tuesday afternoons for shelter care hearings and some permanency hearings. So Tuesday afternoons, if they can fit them in, we will, but otherwise they're whenever. And we had a emergency removal yesterday, and and So when you have emergency removal, the case manager has to write an affidavit that goes to our state's attorney the next day before noon. And then we find out a few hours later when court is. It can be that day or it can be the next day. It is tomorrow at 1 o'clock. So yep, 96 hours of an emergency removal. So I mean, those ones we don't get much notice on at all.
What kind of information is done at that initial one? At that initial, like the emergency, what kind of information? Yeah, shelter care, what is presented in order to make the case for against?
Mostly at those and those emergency shelter care hearings, the judge wants to know what happened. What happened? Why is the child unsafe right now? To have shelter care, you need probable cause. You don't need to prove beyond a reasonable doubt like you would in a permanency hearing. You have to prove it that the child is in need of protection. In your shelter care hearings, you just need the, just convincing evidence for shelter care.
So that initial could just be one incident that was observed or seen and be like, this is bad, we remove them. And then later finding out there was a history of it and there's more evidence to say they need to stay there.
Absolutely. When you're going into that emergency removal and it happened on a Saturday at 1 a.m. and we know nothing about this family and we don't have any history with them, that's what we're talking about is what happened. Yep. Possibly DUI, domestic violence. Yep, arrests.
Gotten lots of kids where they didn't know the name. Yep.
I had parents not be able to tell me birth dates.
Or they spell the kid's name.
Who all shows up for those type of hearings? Like, does a police officer show up, or like who has to be there for that?
Not as much as you would think. Typically, it's the worker who was either on call or was part of the removal, and our state's attorney. It's on the case manager or the worker who did the removal to notify parents of these shelter care hearings because we don't even get 24-hour notice. So it's on us to make sure all the parents are notified in there. Usually if we're going to involve law enforcement, it's when we're getting closer to the trial to ask for the full custody.
We usually don't have people testify other than the worker during those shelter care hearings. They're very short, first of all. Sometimes they're 15-minute hearings, sometimes they're 30 minutes. So there's not a lot of time for extra testimony. But we also need to preserve that testimony for when we actually need it when there is a higher burden of proof, right? So in those hearings, whether it's that initial hearing where we're asking for that first 12-month order, or a permanency hearing where we're asking for another order, or TPR hearing, those we will likely have more witnesses than just us.
We answered everything. 4 more minutes. We are looking for a placement for a 4- and 7-year-old. If anybody is, yep, tomorrow after school. So anybody, I'm going to start going, you. Boys, siblings. You've done it before, Amber. You've done it before. They will. We'll find it. We'll find it.
There.
Oh. Oh. Did you call him back? Oh. Oh, okay, okay. It's probably Peggy.
I was in court this afternoon. I didn't tell anybody.
You guys just use that as an excuse. Were you actually?
She's wearing dress shoes. She was in court.
There was 2 questions that came in online. One of them, I apologize, was a little while ago and I missed it. But when you guys are talking about your new updated information sheet that you give to the foster parent with placement, the question was, who do we contact if we are not receiving the information sheet in a timely manner?
Peggy Netzer. Was it from me? No. It's new. We're talking about it a lot in our meetings to make sure everybody is handing those out.
This is, I think, maybe a good question. Why are we not getting bio parents in front of the court to address why no progress is being made sooner than 12 months? We have seen multiple times where bio parents show up in the 11th month of the order and everything starts over with the court system.
I've had that happens more often, I think, than not. For lots of different reasons. Say that again.
Because of the pressure.
Oh yeah, the pressure. They get notified of court and oh man, they're starting treatment tomorrow and they got a job and they just got a dog and so just trying to be funny. It happens all the time.
Right? When the pressure's on, right? I have a deadline I have to make. Let's get my act. And we don't
Yep.
court calendar. I feel like I said that a lot, but maybe we need to again. Like we don't control that. It's up to the court. It's up to the court when they want to bring people back. The ones where the court feels like, okay, these people are saying they're doing things, but they maybe are not actually doing things. Those are the ones that get review hearings. Okay. If they're parents and we go in and we say, you know what, they're not doing anything. And the parent's like, yeah, I'm really not doing anything. Those are the ones we don't have a review hearing for. Those are the ones that wait another 12 months. So it really depends on the case and the court makes that decision, not us. We can request a review hearing at any time. So if you as a foster parent have major concerns and it can't wait to the time when we're normally going to have court, but remember, we send our affidavits in 3 months ahead. So if your court order expires in June, your affidavit is already in. It's on my desk literally right now. Yes. So it's already in. So if you're concerned about that, just know that like, hey, we're working on it. It's coming. That accountability will be there, but things don't move that quickly with the court system when it's review hearing type things. So we could request a review hearing right now. We still have to write an affidavit for that. So we may as well just turn in our permanency affidavit and go from there, right?
Yeah, they are. No. I do want to just say real quick on that. We have 200 kids in foster care, and if we were having review hearings on all of those kids every 6 months, you'd see even less of us. So
how long has it been a 12-month time frame? Like, has that been in place for a long time? Is that a state statute? Like, you get 12 months? Has there been any? Oh, okay. Has there been discussion?
Not longer than 12 months.
Not longer than 12 months. So in certain cases, you could do shorter then.
Yeah, a lot.
A
lot of times we ask for 6 months, 9 months, but Yeah. 12
I always
is the
struggle, like
max.
12 months for an adult is not much time, but for in a kid's life, that can be a lot of time.
Yeah.
A lot of development happens in 12 months for
Very
a
true.
child.
Yes. Yep.
The jargon used to be 30-60. Like I thought I was cool when I said that. Did you get a 30-60? I didn't know what it meant, but I said it.
That's your shelter care.
Okay.
You can get it for 30 days or 60 days.
And now you don't do that? Now you go to
Yep,
a
we
year?
still do the shelter care.
Do you still call it 30-60? Like
or 60-day order.
Right, 30-60.
I'm okay, we're over time, but the reason we get our affidavits in so early is because if we go past that 12 months of custody and we have to get an extension, the court will say, okay, this order is continued to the next day of court, and we go past 13 months, eligibility won't pay you guys. So we want to get in there as soon as we can so that we don't get to that point. Because if we're like continued out then to 14 months and 15 months, which happens, eligibility will not pay you and they won't go back either. Month 17, basically the zone is cutting the check, is how that works. Shannon. Oh.
Not as efficient if the zone is cutting your checks, just so you know. So if we have to pay you, you have to wait for the commission to like approve the things, and someone has to write the check and mail it to you. Whereas if the state's doing it, it's like we send an email and boom, it's in your account in 2 days. So we really try to avoid having the zone pay for things. We will do it when we have to, and court is one thing that we don't have control of, so we have to. But we try to be as efficient as possible for you guys when it comes to that. So that's why we're doing those orders so early, or affidavits.
Shannon. The 2 kids? Oh, 2-year mark.
Closer to the 2-year mark without any progress. Like, what does that look like? Like, they're starting to talk, but they're only starting to talk about maybe changing things. But I'm like, to me, I feel like that's a lot of pressure and not enough time. But I don't know, like and you're like 3 months in advance. I'm like, oh my gosh, that's even less time.
What do you mean? Like,
okay, so the order is going to be up.
Like you're coming up to year 2.
Yes.
We're halfway through year 2.
We're in 2.5 years.
1.5 years.
1.5 years.
So September will be year 2, and the beginning of June, they are going to possibly change the order from reunification to concurrent plan of adoption as well. But that decision is not being made, and they're not even sure if they're going to make it then. And I'm like, but at that point, we're 3 months away from the 2 years. So that's okay, because that's always...
It really does. And like, we can write a TPR affidavit anytime. So they can add that concurrent plan on in June, and they can write an affidavit in June, July, August. Our rule of thumb is we write a TPR affidavit the same time we write a permanency affidavit to keep them kind of together in court so that we're not in court even extra. But I think just having those conversations with your worker and don't be afraid to ask questions about what it looks like and how that's going.
And so I would say, so like I said, things happen behind the scenes that you as foster parents aren't part of because like you're not the case manager. But if you know that they're adding a concurrent plan of adoption, there's a pretty good chance that they've already had a lot of conversations with the bio parents, their supervisor, their state's attorney already, and that they may have already written that affidavit by the time you get to your next team meeting in June. And so when they say we're adding a concurrent plan, they will have an adoption worker at that meeting. They will be prepared to file that affidavit right after that meeting. So it could be a situation where they're saying, we're waiting until June because we need to file a permanency affidavit in June anyway. So for efficiency's sake, let's do it all at once. Yes. Trust the process, right?
Is that when your next team meeting is?
Well, no, our next one was, no, we just had one, but we just had one, but they didn't bring ask to that one. So in that team meeting, they decided they're going to have another one sooner than the one that's due.
We did decide that one was gonna be a guardianship.
That was a last second decision because going into it, they said they weren't gonna do that.
But after she hung up on the call, yeah, that's when they decided to do that, so.
Sure. Yeah, we can do those child and family team meetings sooner than 90 days if we need to. And with the new adoption redesign, and like Peggy said, if we're gonna add a concurrent plan of anything, we've already discussed this with our supervisor and our state's attorney before we come, and our field service specialist, before we come to the table and say that this is what we're going to recommend or this is what we're going to do. And so we want to have the adoption worker from Ask Catholic Charities be present for that meeting that we add that concurrent plan on. So it seems like they're trying to do that the right way there.
Step-by-step process.
Yeah.
I just want to make sure I'm understanding when you said you don't want it to get past the 12 months into like the 14, whatever, so you go with a 3-month rule because you want to make sure that court can get scheduled. Is that what? Okay.
Yeah. We want to make sure that we're scheduled in that 11th month or, the very beginning of that 12th month or, so that we have enough time, because let's be real, most of the time you go to court and it does get continued because someone wasn't served properly or someone wants an attorney when you get there. There's lots of different reasons that it can be continued. So we try to get in there earlier.
I'm sorry, different case, different kid, 18 plus question. Okay, so I had an 18 plus before, but before he could get to court, he ended up getting kicked out, which is fine, but it took a long time for payment because they didn't have the order. Well, I have a new kid who's just turned 18. They do have a court date scheduled, but like, are they cutting it off the order when he turns 18 and then redoing it?
Yes. Did you guys sign an 18 plus agreement?
Yes.
That's when the court date will start.
90 days
to get into court and get your order, but the order will start on the day of that day of your 18 plus agreement.
That they signed it. Okay.
That answer your question?
Yeah.
Really appreciate it. A lot of good information. Don't forget to get your kiddos. I'm hopeful that the babysitters are still alive. It sounded a little scary back there. So, okay. All right. So thank you for coming. We'll be putting some dates out as far as the picnic and information that you need to know for the next few months.